Welcome. In this video presentation, we will delve into the fascinating world of digital forensics search warrants. We will examine two specific cases where digital forensics and evidence played a pivotal role in solving complex criminal investigations. We will explore the legal nuances, potential challenges, and practical considerations surrounding these search warrants. Reviewing search warrants is crucial for understanding the digital forensics process because it provides insight into the legal framework and investigative procedures that digital forensics examiners and law enforcement officials use in real cases. As we go through these, consider the context, legal boundaries, and procedural guidelines that we've been studying. Remember that well-written products such as search warrant affidavits enhance the overall quality and reliability of digital forensics investigations. So on your screen is a QR code that you can use to follow along and read the entire search warrant. This is a search warrant from the District of Utah, and it's authored by a special agent from the United States Air Force Office of Special Investigations. In this video, we won't delve into each and every part of the search warrant, but we'll be kind of skimming over the highlights, and then you can read them at your leisure. So let's start with the basics. At the very top is what's often called the caption. So this is what really kind of identifies what is going to be searched and seized. It gives the case number and so on. Next, you'll find the brief summary of the investigation. In some cases, there's a description of the agent's background. We'll get into more of that. But really importantly, it also includes that legal authority to compel the seizure. And in this case, it is, again, these are all federal search warrants, so we're using the Federal Criminal Code. So as we discussed, it's important to lay out your training, your qualifications, your expertise, and your experience. So in this case, the agent is with Air Force OSI. They indicate where they are stationed and how long they have been a special agent. They go into the basic training that they receive at the Federal Law Enforcement Training Center or other areas. And they also kind of give a general overview of their authority, where their jurisdiction lies. Secondarily, it's also important to know and be able to articulate that you have experience investigating the violations that are at issue in this particular search warrant. So, for example, this is a wire fraud, false claim, and conspiracy case. You want to be able to demonstrate that you actually have experience doing those cases. Or in the alternative, you've been trained on them from others, and you work with other agents, investigators, analysts, forensic auditors, etc. Now, in this case, again, they reiterate exactly what the criminal violations that are under investigation are. Next, they discuss the kind of the targets of the investigation. So in this case, a president of a company and where that is. And then the fact that there is believed to be probable cause to search the information. Remember, we're trying to show that the people have access to the material, and the material is where we think it is, and finally that it will be helpful in the investigation. So in this case, the agent provides a summary of the investigation. I think this is really important, especially for more complex cases. So in August of 2021, the target company was awarded a contract for radar, and essentially what they believe happened was that the individuals involved, who are owners of the target email address, and the company, uh, utilized falsified prices, inflated invoices, and intentionally omitted a very large portion of requirements so that they could win this this contract. And next, you really want to be able to show how in this case, the target email address was used by the individuals. Um, and obviously, communication is key in these cases. So remember, person, the device or the email, and tied to the criminal activity. That's really what we're trying to get to. So now, again, we have some further information here. It appears that there has been some collusion with government employees who are known but are not identified. And essentially, the idea is that um, using the employees, um, the target company then provided them documents that really should have been produced by the government. And this enables in a contract fraud matter, for the company to be better able to position themselves to win the contract. You'll also note that there is a agent note in here, and I am a big fan of agent notes. I know some people aren't. Um, Agent notes are really important to be able to explain certain issues, such as here the um, contract process can be quite intense and opaque in some ways. Again, we're writing this for a independent, neutral magistrate who has no idea about government contract procedures, and so we want to be able to provide them some further information. And they also note that so it's easy to believe that um, the investigators already have the government employee email, because you don't need a search warrant for that. Um, and here you have an email basically saying, hey, we've done this for you, um, and basically put it on your letterhead type of thing. All right, here we know that the agents do have the emails of government employees because they are not subject to the expectation of privacy. And here we have some really interesting knowledge, where target number 2 basically says, hey, make sure my name is not associated with these. Um, Again, they had produced this document. Presumably the properties and the metadata would have shown that, and that obviously is a problem for them. And they know it. Again, this is where digital forensics is really important. Here we also have some information to suggest that the company submitted inflated invoices. So we probably have some forensic auditors who are looking at everything. All right, let's talk about the four corners. It's important to understand that information not contained in the search warrant affidavit cannot be considered by the issuing official to determine whether probable cause actually exists. It has to be included, recorded, or contemporaneously summarized. And that's called the four corners rule. This is because the issuing official, the judge, a judge at a suppression hearing later on, can only consider the information that are within the four corners of the affidavit. So in this case, one of the things that's important is how email works. And I know this is kind of silly in some cases because we all know how email works. But importantly enough, because of the four corners rule, it's something that you really need to take into consideration. So a lot of this is pretty standard and boilerplate. But it is important to understand that you really have to be able to articulate, based on your training and experience, what information they have and why that matters. So for example, and I included this part, email providers generally ask subscribers to provide certain identifying information. So this could include all sorts of things that could be useful to the investigation. Now also, in my training and experience, information could constitute evidence of the crimes, or it could also be used to help understand who is using this. Based on my training and experience, even when subscribers insert false information to conceal their identity, this information often provides clues to their identity, location, or illicit activities, right? So again, really, really helpful to be able to move the investigation forward. And as we move through the case, again, we're talking about why it's important to be able to find this information and material and what could be located inside it. Information in an email is often used to provide crucial evidence of the criminal conduct, and that is important here because it establishes or proves every element, or importantly too, to exclude the innocent from further suspicion. It's really about finding the truth. The agent is able to say that they know about this thing called user attribution. And that's kind of that indicia of occupancy, the legal concept of, hey, how do we know that this person is actually here or this person is using this device, right? Those are really important elements because they could be defenses, and we need to be aware of that. So every search warrant has usually an attachment A, which describes the place to be searched, and then attachment B, which is the information to be seized. And this is really important, right? So this is, again, sometimes boilerplate, but also needs to be looked at in the context of the specific investigation. So records of communication regarding bid rigging, false claims, bribery, conspiracy, how they are involved in the bid process, specific other bids that have been submitted, photographs or other communications regarding bid rigging, market allocation, wire fraud, and conspiracy. Again, evidence indicating the owner's state of mind, right? Again, we have to prove intent, and intent is often difficult. But when we have evidence in the person's own words, that's really, really helpful. All right, let's move on to warrant number 2. This is for an iPhone. So this is for a device. This is from the Southern District of California. It's an HSI, Homeland Security investigation agent. Again, use the QR code. You can follow along. You can read the whole thing. So this is a much shorter affidavit, much simpler in many ways. Again, many of the same concepts that we did in the other one. but let's look at this in terms of its identifying the actual item. It has a seizure number. In many cases, I would recommend other identifying information, not just the seizure number, but that's okay. Again, what are we searching? How was it seized? What is the crime being investigated? And what evidence can be found on that? Next, the agent goes in to talk about the background, again, length of service, types of training, previous investigations, jurisdiction, venue, all that. So this is a case involving narcotics trafficking at the border. So again, here it's important to talk about what they know, common practices. Narcotics traffickers often work in concert utilizing cell phones. It's a common tactic. They talk about how these things work, how they play out, what we call TTP, tactics, techniques, and plans, right? So we really want to be able to understand how these things go. He provides an example that narcotics traffickers frequently communicate with those who are transporting the material so that they track them. They know what's going on. They can warn them about interdiction or law enforcement activity at the border. And then, of course, they want to be able to make sure they get their stuff or it gets to where they intended to go. So again, in this case, you have iPhones that were seized. This is talking about the types of information that could be gleaned from those. For example, travel, presence of locations, things like that. So again, we're looking at all the different information that could be stored. Again, you see this is a little bit different format, but that's okay. It contains essentially the same information. So next, the agent talks about the facts that support the probable cause. So in this case, there was a individual, U.S. citizen, who came in through a port of entry in Southern California through a vehicle. The individual provided negative customs declarations. I have nothing to declare. However, open the trunk, and guess what? You've got packaging consistent with drug trafficking. The investigation further reveals 138 packages weighing 143 pounds, concealed in 4 doors, the firewall, dash, quarter panels, rear bumper, fender. Field testing showed that they were meth. And of course, the individual denied that they were trafficking drugs. They had no idea what was going on. Giving a statement after Miranda that, they were paid $1,500 to bring medicine into the U.S. And he also said that he was the owner of that specific cell phone. Remember, so we're actually looking at the cell phone. So this is not a photo of the investigation, either of them, but to just show you like what a port of entry kind of looks like, and then the what smuggling packages kind of looks like. These are both from CBP, but again, these are not case specific. It's important to talk about the methodology. In this case, law enforcement had previously attempted to obtain evidence in this warrant by downloading the phone in the field, and it was successful. They used a Celebrite download, and under consent from the individual. However, it does not capture materials such as deleted text messages and other things. So that is why the warrant was requested, basically to further the investigation. So again, this is a discussion about the methodology of the phone, what information is on it. And again, this is one of those things where it's like, okay, we have enough information probably to start, but we really need a deeper dive, right? We're looking for much more information, and we really need to send it to the lab. And so that's really what this is going through. All right, as we wrap up, let's talk about the legal context, right? The evidence triangle is the framework used to evaluate the reliability and admissibility of evidence in court. First, information must be relevant to the case. For digital forensics, this often means that it needs to directly relate to the matter under investigation. So for example, emails, chat logs, files found on a suspect's computer, these can all be relevant to the issues at hand. Next, we talk about reliability. Digital evidence must be reliable and authentic. We talk about the best evidence rule to ensure that we're presenting the most reliable form of the evidence, often the digital, raw digital files rather than a printout or a copy. And of course, this is also making sure that it's the integrity is crucial. We don't want it altered or destroyed. And finally, sufficiency. We want to make sure that it's sufficient to support the case. Remember, this means analyzing data from digital devices, computers, phones, servers. The idea is to reconstruct events, establish a timeline, understand the actions involved, and really using specialized tools to extract this data, because we need to be able to identify the material, the elements, and it's important to be able to showcase that, right? Remember that digital evidence can also cross jurisdictional borders instantly, making it both powerful and challenging for law enforcement agencies. So if we think about this triangle strategy, relevant, reliable, sufficient, we can make sure that we have the data that we need and are able to use it successfully. So again, just to summarize, we need to think about the crime under investigation, the location or item or device or email address at issue, the people and how they are connected, and the facts. And again, this is all about connecting the technology and the device, the evidence that's already been gathered, and then how we're pulling it all together. Probable cause is defined by the totality of the facts and circumstances. It's important to be able to use reasonable and trustworthy information. We want to make sure that a person reading this believes that an offense has been committed, and the evidence of the crime would likely be found in the particular place or on the person that we suspect. Probable cause is based on everyday logic, common sense. The logical inferences which can be drawn from the facts and evidence, the circumstances, the person, are included in our probable cause determination. Facts and circumstances must be logically made probable to show that the seizable property is located in the particular place. Remember, absolute certainty is not required, nor is proof beyond a reasonable doubt. Probability is enough. Facts and details are crucial to this. We must establish this. Here's a quick way that I think about this. Using the acronym FACTS, you can write a PC affidavit. Facts are those verified details, the who, what, when, where, why, and how we know. The A is about analysis. What is the background? What are the logical inferences? What does our professional training, experience, the use of experts, what does that tell us? How do we corroborate this information? How do we use multiple sources to be able to know that we have reached a correct conclusion, right? What is that conclusion? T is for tie-in. It's about nexus. How are these all connected? Remember the previous slide with the triangle. We want to be able to show all of those in connection. And then finally, summarize. We need to put together a cohesive story that shows what happened, why we think it matters, and what we're asking the judge to do about it. Well, that's the end of the presentation. I hope you enjoyed it. I hope you go back and read those affidavits and read more. And if you have any questions, feel free to post them on the discussion board, and look forward to talking with you soon. Take care.